People are coming back into the room gradually, and we've got two more topics to discuss, representing families and Section 57 applications. We might start with the Section 57 applications. Section 57 in relation to privilege and self-incrimination. If you read the section, it's couched in so many double negatives that it's really difficult to understand. But if you sit down and analyse it, it's actually quite straightforward. And I've made a little notation which might assist you, that the steps that need to take place are, firstly, the witness has to formally object to giving evidence on the basis that the evidence may tend to prove that the witness has committed an offence or is liable to a civil penalty. Civil penalty means, for example, disciplinary sanction that might be imposed in a professional body or VCAT. So the witness has to formally object, has to come in with the lawyer and say, look, I formally object to giving evidence. And then the coroner has to decide whether there are reasonable grounds for such an objection. And if there are not reasonable grounds, then the witness has to give evidence. If there are reasonable grounds, two things follow. Then the court is not to require the witness to give evidence, but A, may compel the witness to give evidence if it considers the interests of justice demand it, in which case a certificate's granted. Or you might have another scenario where the witness is nevertheless prepared to give evidence without being compelled, and a certificate will be granted to the witness in those circumstances. And so, Megan, a judgment has to be made about as to whether, in fact, one makes an application for a Section 57 certificate.
Yeah, and there'll be all sorts of circumstances that might affect that decision. A good example is if you've got a professional client who may potentially face a disciplinary sanction as a result of their conduct that's also in question in the inquest, you might want to think about whether seeking a certificate is necessarily a good idea. For example, typically when you go before a disciplinary board or tribunal, insight is perhaps the most important thing that you can demonstrate. And if you have got into the witness box in an inquest and given honest evidence, given detailed evidence, and shown that you have insight into where things went wrong, why they went wrong, and that you have taken all the appropriate steps to ensure that they don't go wrong in the same way in the future, it might be better to be able to rely on that evidence when you come to disciplinary proceedings. And it might also encourage the disciplinary body to not bring those proceedings at all. So there are going to be situations where seeking a certificate is actually not going to be the best choice for your client to make, but that will, of course, be a question for weighing up on the particular circumstances.
I suppose if you had a prospect of being charged with a criminal offence, the first thing you'd be doing is seeking to ensure that you just didn't give evidence at all.
That might be the case. It might be the case. Sometimes it might not. And I guess there are... These matters are always going to be difficult decisions, and they're going to be decisions that require weighing up. I think in the vast majority of cases where a witness faces a serious criminal penalty, then they would be likely to try to avoid giving evidence completely. There have been situations, and there's one which is referred to in the paper that is quite an interesting scenario, and that's there was a inquest into the death of a Mr. Joannou, that's Joannou, and the death was a police shooting. The police members of the Special Operations Group had attended at a property, and they were attempting to arrest Mr. Joannou, and in the process shot him. And there was a serious potential that one or another of the members of police might face a criminal prosecution for the shooting death. There were 4 police officers who had been put on the coroner's witness list, and 2 of them may have been the ones, so 2 of them discharged their firearms, and the bullet fragments found in the deceased matched back to their particular firearms. And so there was a serious issue about whether those particular police officers could face criminal prosecution. And the coroner who was hearing the inquest heard the objection of those 2 officers who were due to give evidence on the second last day of the inquest, and they objected to giving evidence on the basis that the evidence might tend to incriminate them. Found that there was a reasonable basis for that objection. And then the witnesses indicated that they were, however, willing to give evidence under the protection of a certificate, and indeed they wanted to give evidence. And the coroner required their counsel to make submissions about why they wanted to give evidence, and there were, in the course of submissions, there was some suggestion on the part of counsel assisting and the coroner that perhaps there was some suspicion that the particular police officers wanted to give evidence in this proceeding under the protection of a certificate, and that there was concern that that desire might not in fact be that they wanted to put their version of events forward, but that they wanted to be protected by the certificate, so that both the evidence they gave and any evidence deriving from that evidence couldn't be used in a future prosecution of them. And so there was suggestion that there was concern on their part to try and obstruct any future prosecution by using these certificates to their advantage. It was never explicitly said, but that was the feeling in the court. And the next day, so the coroner gave an indication that she would not call upon these witnesses, and that in her view it was not in the interest of justice to potentially prejudice a future prosecution of those particular witnesses by calling their evidence, and instead would hear from the other 2 police officers first, and then only if there were evidentiary gaps potentially call on the 2 police officers in question. The next day, after some fairly vigorous argument, you get the feeling, it came back on, and the coroner announced that she would refer the matter to the Office of Public Prosecution under the Section 49 power in the Act to refer a matter for consideration of whether a prosecution should be brought. And the matter went off. The Office of Public Prosecution considered it and decided that there wasn't adequate evidence to justify a prosecution, and the inquest resumed. And on the resumption of the inquest, the police officers brought a application to the Supreme Court for an order in the nature of prohibition to prohibit the coroner from hearing the inquest on the basis that of apprehended bias. And in considering the case, Justice Kairu found that there wasn't a basis for prohibiting the coroner from continuing to hear the inquest, and that there was no apprehended bias but did find that legal errors had occurred. In particular, the error that's relevant to interpretation of Section 57 is that Justice Kairu found that if a witness makes the objection and then the coroner takes the next step under Section 57, subsection 2 of determining that there are reasonable grounds for the objection, but the witness then is willing to give evidence under the protection of a certificate, the coroner does not then go to the next step of considering whether the interests of justice require the coroner to force the person to give evidence. So by taking that next step and determining that the interests of justice required the coroner to forbid the witness giving evidence, the coroner committed a legal error. So it's an interesting decision from that perspective. It's also interesting that Justice Kairu found that the plaintiffs, the police officers' motives for wanting to give evidence under the protection of a certificate cannot logically be equated with a suspicion about the veracity of the evidence to be given following the granting of such a certificate. A certificate cannot be obtained unless there are reasonable grounds for an objection that the evidence to be given by a witness may tend to prove that the witness has committed an offence. Ordinarily, witnesses do not tell lies that would incriminate them. And he found that even if the coroner did suspect that these witnesses were trying to get the protection of a certificate for an ulterior purpose, that was not adequate to show apprehended bias, because she would still consider the evidence to have been true and would consider it appropriately in the exercise of her inquest duties.
We better move on to the next topic, I think.
Sure.
Just before we go on to the next topic, can I just raise one issue about Section 57 applications? Bearing in mind one of the issues is reputational issues relating to clients. The fact that a Section 57 application has been made can be reported in the press, and so when you're considering whether it's appropriate to make that application, bear that in mind. Irrespective of the outcome of the application, the fact that the application's made is reportable, and that could be something that you may not necessarily want to have publicised against your client.
Just as one final matter, there's an error at paragraph 3 of the paper, which talks about the considerations that a coroner must make in terms of determining whether to require the witness to give evidence. There should be a further part of a sentence before the word "and," which is in italics. Subparagraph A of Section 57(4) says that the coroner may require the witness to give evidence if the coroner is satisfied that the evidence does not tend to prove that the witness has committed an offence under a law of a foreign country. So presumably the law is intended to protect people who might be subject to prosecution in a foreign country where our particular legislation can't control the way that evidence in an inquest is used in that country. And then the coroner must consider whether the interests of justice require that the witness give evidence, and that's usually the primary consideration that comes into play in these cases.
If we can move now to the final topic that we're going to discuss today is representing families. Megan, one of the points that you make is how it is, or the question is, who is my client? I think it's important, particularly given that we've got solicitors here from plaintiff firms who represent regularly people, family members of a deceased at inquests. Solicitors need to be confident that there's a uniformity of instructions coming from family members they represent, otherwise there's the potential for an awkward conflict of interest that arises at an inquest. I had one recently where I was looking after a midwife who delivered delivered a baby in a home birthing pool, and the baby lived, but the mother sadly hemorrhaged, postpartum hemorrhage. One isn't too sure, frankly, but we had the plaintiff or the representative of the family had an awkward situation arise in circumstances where the husband of the lady who died was all for home birthing and midwifery delivery and management of the pregnancy, whereas the mother of the lady who died, she was all against the idea of home birthing right from the outset, didn't want her daughter to be involved. So we had one family member wanting to be critical of the midwives and another family member wanting to be critical of the midwives. And this arose, and the coroner said, well, look, I'm not going to have 25 people from the family being represented. I just want one represented, and I'll allow the husband in this instance to be represented. And insofar as the mother of the lady is concerned, I'll allow her representative to ask questions which aren't asked by the representative of the husband of the deceased. And so solicitors want to be conscious to avoid that potential conflict, don't they?
Yeah, it's an important thing to think about whenever you're briefed by a family. Of course, in many cases you'll be appearing on the instructions of senior next of kin. However, often behind the scenes you've got the rest of the family who are all wanting to take part, and it's a difficult issue to deal with in any situation. And of course, our rules of professional conduct relating to conflicts of interest still apply to our conduct in inquests. In many situations it'll be fine. You'll have a family who is, at least in terms of the key issues that are to be considered in the inquest, they agree. But you will have situations from time to time where you need to turn your mind to the question of where my instructions are coming from, what my instructions are, and do they have any conflict with the position taken or the interests of other members of the family who may need to be separately represented. Of course, in a situation where you're acting for a family who may be under suspicion or may potentially face a prosecution relating to the death of a family member, in the vast majority of those cases, you're going to find you need to, those members of the family need to be separately represented. And where that might be the case, you might, for example, have an infant death and there is some potential that mum and dad might come under some suspicion. Even if mum and dad are at that point presenting a united front, you would want to turn your mind very seriously to the question of whether there's a prospect of some sort of conflict arising at some point, and whether it's in the better interests of your client to ensure that they're separately represented.
Megan, I'm conscious of the time, and I'm sorry to cut you short.
No, not at all.
If you don't mind, we're just going to deal with this topic of revival of users forum. That will take 1 minute, and then you're free to head off. You're probably very keen to head off, but those of you who would like to ask questions may of course remain, and we'll field them.
Just wanted to bring to people's attention that there is a users forum that has been revived by the Chief Coroner, Judge Gray, and at the moment it's a combined Health and Legal Counsel and Court Users Forum. They had a meeting at the end of October. It's a forum where issues can be raised and ventilated with the Coroner's Court relating to release of information and things like that. I'm informed by a person who was at that meeting that one of the issues that was raised was the provision of transcript, which all of us know that when you're running a coronial inquiry, getting a transcript weeks and weeks later is a very difficult position to be in. So that has been raised, whether there are any improvements. We're told that the time has been cut down from 2 or 3 months to 2 weeks or so. But in circumstances where in every other court of the land we get a or higher court of the land, we get a running transcript, maybe that's something that hopefully will be addressed. But there is a forum where those sorts of issues can be now raised.
All right, so why don't we head off if we want to, or ask some questions if we want to.